You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, shall be heard. God save these United States, great state of Florida, honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case of the day is Philippe versus State of Florida. You may proceed.
Good morning, Your Honor. My name is Dave David, representing Mr. John Philippe in this capital murder. Case arises out of Jacksonville, Florida in August 2000. Stabbed his wife. During this summer of 2009, it was clear to Mr. Philippe and his wife were heading towards a divorce. He was trying to stop that, talk with his wife. 21st of August, feeling like they needed some time to, let things off. He had flown back to Rhode Island, where he grew up. But after a couple days, he came back to Florida. And on the way back, was trying to talk to his wife, and she was either saying, "I'll talk to you later," or just saying, "Don't talk to me." He got into the airport, Jacksonville Airport, about 7 o'clock that evening, and then immediately began trying to contact his wife on his cell phone. And during the course of a couple hours, he said about 70 times, either contacting him or his sister-in-law. His wife, Elkie, had actually gone to the airport a couple hours after he had gotten there and picked up her sister. She had flown in from California. They were going to go to Miami for a birthday party the next day. Well, in any event, she and Elkie and Roya, that's the sister-in-law, go back to their apartment. Elkie puts her 5-year-old son into the bathtub. They then begin trying on clothes. A few minutes, sometime later, there's a knock on the door. Somebody announces, the defendant says he's the pizza guy. They're suspicious. Roya, the sister-in-law, gets a knife, comes to the door, opens it, and John Philippe, comes in, hits the sister-in-law in the forehead one time, and then goes and with the tire iron, right? Tire iron that he got from Elke's car sometime before he got knocked on the door. In any event.
Well, are you saying, as you go through the facts, that he was coming in to try to reconcile with the tire iron?
Well,
in other words, I'm thinking that you're trying to dispute the judge's finding of CCP.
That's correct.
Where you're going
yes,
on
that's
this.
if you don't mind. In fact, I'd like to talk about that first. Maybe address that might be better. But anyway, he was found guilty and found 3 aggravated.
But you would agree that the idea that, and I think that he's coming in with the tire iron, and the whole pattern of his behavior was not one where he had any hope of reconciling, and the reasonable inference is he was coming to kill her.
Well, no. And I say that because he had been trying to text his wife. In fact, one of the messages that came in that was over objection was even up to the very end, he was saying, we can work this out. If we're going to get divorced, let's don't part on. Was
there an adult male in the house?
No. There was just the 5-year-old son and the 2 women. So no.
What's the self-defense thing? Okay.
No.
If he was going there to work things out in an amicable fashion.
Well, if he was going to work things out, he wouldn't have. Why didn't he kill his wife with a tire iron? And he didn't. It was with a knife. It was a knife he had found. Obviously.
He might have thought the knife would work better.
The knife, and he's already got the tire iron. Why not just complete what he's doing with the tire iron? But he doesn't. He uses a knife.
It wasn't a tire iron. Actually, the actual jack.
Well, I think it was the tire iron. The thing you crank it up. It says a tire.
I think the record says that he actually brought the actual jack.
That may have been. It was something connected with changing a spare tire.
And that tire jack came out of the victim's car.
That's correct.
Not the car he was driving.
Well, he didn't. Apparently, he didn't have a car because he had to wait for her to come back from the airport to go get the tire jack, the tire iron, or whatever it was.
So if I get the story straight, because you're talking about CCP, right. He is sitting outside waiting for them to get back. They walk in, her and her sister.
Right.
And then he goes, gets the car jack.
Right.
Knocks on the door, beats a man.
Right.
As soon as she opens the door, he bang right in the head with a car jack. That's his sister.
Sister-in-law. I'm sorry, it was her sister. Yeah.
Her sister.
Right.
Right in the head. And then he walks in and starts stabbing her 52, 53 times. Now, How is that not? It seems to me like if ever there was a case of heightened premeditation, is somebody lying in wait to kill somebody?
Well, is he lying in wait? The court said he was, but he really didn't have much choice. She was coming back from the airport.
Really.
What about the tire iron, though? That's the problem we have here. Now, he's coming there to extend the olive branch with the tire jack. And you ask, well, why didn't he hit the wife with? Because it wouldn't kill it. Didn't kill the sister-in-law, did it?
Well, he only hit her once.
Did it kill the sister-in-law? Okay.
No, I only hit her once. But why go after? Why? There's a problem there. Why bring a tire iron to? Like you say, Justice Kennedy, why bring a tire iron if you're going to extend the olive branch? But it was clear that the wife was trying to put him off. Now maybe
he was lying. Here is the deal. You could. This might be a jury argument that you could make, but we're here on the issue of CCP, if that's what you've gone to, see whether there's competent, substantial evidence to support the judge's finding. It is, to me, most respectfully, illogical that he was going there to try to work things out, because as Justice Labarga pointed out, as soon as the ruse was used to gain entry, and as soon as he comes in, what's his first thing he starts to do? He starts beating
sister-in-law.
Right. Well, so what? And then, because he thought the sister-in-law...
And then...
It doesn't... It's just, unless you have some other facts that would be overwhelmingly persuasive, I just don't see that this is not a case of CCP.
Well, I just can't understand how a man, if he's going to kill his wife, gets a tar jack and then says, oh, well, I don't want to use it. Let me go find a knife.
Well,
that doesn't make any sense.
Not every... In fact, over 15 years, and you have been doing this longer than I've been sitting here, there are many of these first-degree murder cases where the defendant is not 100% logical. Maybe if he was a wealthy man, he would have hired a hit person and had them go in and kill the wife. But he was certainly a person that was emotionally upset. Now, if you're going to say then that CCP doesn't apply because of that, we have cases that say that just because you're emotional about it isn't enough to defeat CCP. Right. So the fact that it isn't the way someone else might have killed their wife doesn't take away from the fact this is CCP. Is it classic? No, it's not classic, but it's certainly very consistent with many cases where we found CCP.
Okay, well, let's look at it this way then. The tire iron, the fact, there's two facts I'm looking at that show a lack of CCP. We'll look at, the emotional, that's beside the point right now. But two facts. One, he didn't stab her, he didn't kill her with the tire iron which he brought in. I use that as a fact, okay, because he dropped that and got the knife. Okay, now you were obviously disputing that, okay? But the one thing that really becomes hard to reconcile with CCP is why did he then try and commit suicide? This court in Hardy has said...
Wait a minute, that's another point now. He said he intended to do a murder-suicide, so he didn't go in there to extend an olive branch.
I don't recall him saying a murder-suicide. I think it may have come out later. That may have been suggested. I think that's what the state.
Didn't you just say he was going to commit suicide also?
Well, I don't recall him saying.
Didn't you say that?
No.
Oh,
no. I'm sorry. No. What I did say is.
Suicide?
Well, yes. What he does is, after he kills his wife, he then makes some ineffectual efforts to stab himself in the stomach. Does it. Apparently, it's just not very they're superficial wounds. But then he cuts himself fairly seriously in the neck. And when the police and paramedics find him, he's laying on the floor, unconscious, in shock, and not breathing. This court in Hardy has said that shows a lack of calm or cool reflection. Okay, if you can't get over the fact that he killed his wife with a knife rather than the tire iron, how do you get over the fact he tried to commit suicide? How is that? Just as this court said in Hardy, that goes just right in the face of being something that's calm and reflective.
Well, how does that change what his plan was before he committed the murder?
Well, it shows a lack of cool reflection. The guy clearly realized what he had done. Justice Prienti said, "Well, we've rejected cases of emotional frenzy." Well, if that's the only thing you got, perhaps. But when you have an emotional frenzy to the point where the guy is going to try and commit suicide and make a very serious effort at doing it, I think that.
But if his plan was, I'm going to kill my wife and I'm going to kill myself, does that take away from there being CCP? What if it was she had Alzheimer's and he came there, he says, but I can't live without my wife, so I'm going to kill my wife and then I'm going to kill myself. Are you saying that wouldn't be
No,
CCP?
I think that probably could, but we have no evidence he was intending to commit suicide before he actually did it, or tried to commit suicide before he actually did it. What oftentimes happens, these guys see what they've done, and then the remorse.
But if that plan is formed after he has already killed the wife, it really doesn't negate any of the other factors that demonstrate that he intended and planned to kill his wife.
Well, I think it does. That's what you said in Hardy. You said it doesn't show a cool and reflective thought. So, it
doesn't show cool and reflective thought about him attempting to commit suicide.
No,
but it doesn't, in my mind, negate what he did prior to that.
Well, then you're going to have to re-examine Hardy, because that's what you said.
Now Hardy was, how old was Mr. Hardy?
I don't remember.
You're talking about the Palm Beach County Hardy?
I think so.
He's 17 years old, or that he was confronted by a police officer. He panicked.
Right.
And you're saying that's the facts of that are somehow similar to.
Well, the attempted suicide. That's.
Well, that was. But again, you can't pick out a fact and say we didn't. You said in Hardy because in a case that someone attempts suicide after they kill the victim, that there can't be CCP? You think Hardy stands for that proposition?
I think so. Not as a matter of law, you can't, but I think it certainly is a very strong factor showing a lack of
Do you remember? Give us the facts of Hardy, because you're saying that we'd have to recede from Hardy.
Well, I think it was like you say. I mean, as I recall, the cops had stopped him. I think there was maybe some drug possibilities there.
He panicked.
And he panicked and shoots the cop. And then afterwards, he I think, tried to kill
So how
himself.
is that? That's not even CC. That wouldn't be CC. I mean, that's why the court must have found no CCP.
Well, no, you said. I mean, what you said was that. I mean, it's not the crucial. I mean, it's not the end-all factor, but it becomes an important factor that whether in Hardy or in this case, it shows that the man has an emotional frenzy, and to show that how severe that emotional frenzy is, afterwards he tries to commit suicide.
You know what I find interesting is that although you attack CCP, you don't attack the lack of the finding of the statutory mitigators. Not that the two necessarily mean the same thing, but what did the court find as far as the mental state? Didn't the court weigh it and give it very slight weight?
Yes.
Which is another thing, and you haven't attacked that separately. You haven't said that the weighing of that mitigator was error. So we really have a sentencing order where you've got all these strong factors for CCP and very weak mitigation.
Well, I don't think. I mean, I don't particularly think the facts supporting CCP are particularly strong. I mean, I sense a little bit of disagreement here, but I really don't. I mean, when you look at what the judge is saying, he's saying he snuck back into Florida. Well, he snuck back in Florida because his wife wouldn't answer the phone. He says he got a weapon. Well, he got a weapon. That's true, but it wasn't the murder weapon. And I think that's important.
Now, even if we were to, which as you can see, it doesn't look like we would, but even if we were to say there wasn't CCP. You've got HAC. Now, you haven't contested HAC.
Well, I attacked it. I said the court gave it improper weight. I mean, it's not a particularly strong argument, but
yeah, it's not. I mean, this woman, this poor victim lay dying for quite some time, and you've got the attempted murder.
It's aggravated battery.
Aggravated battery of her sister. So those are, and very little mitigation. I would be hard-pressed to think that even without CCP, this is a death sentence that is not proportionate.
Well, one of the reasons I raised the HAC thing is to show that even though she was stabbed 52 times, there is some mental mitigation there. And I argued that he was in an emotional frenzy. And I realize, you haven't said that that's enough to defeat CCP, but still the man certainly is very upset. He is as his wife would say, he's a controlling sort of person, and he's basically lost control over this situation. And by the time he's got back to Jacksonville on the 26th of August, his wife has just accentuated that by refusing to talk with him. And that's what he wanted. That's what he wanted to do. At least, that's kind of what controlling people want to do, is they want to talk things out. And his wife.
No, controlling people don't want to talk things out. Controlling people want to control. And when he realized he couldn't control his wife, he decided she was not going to be part of this world anymore. And it is the basest of motives on a person that was educated. Did he go to college, this defendant?
He was in college, yes.
He was in college. He was in the military.
Had been in the military, yes.
Been in the military. And he didn't like the fact that his wife was going to leave him. But
I don't think you can infer from that he was going to kill her.
Not that. No, that wouldn't. We would hope not, because in this state we have, a high number of situations where there's a divorce.
Right.
Now, we would hope that's not how someone does it. All I was saying is that you were saying he was controlling, and therefore he wanted to talk to her. To me, the fact of his personality would suggest he was not going there to talk to her.
Well, he'd been trying. For the hours immediately before they got home. She made 70+ phone calls to her, few unsuccessful. Just constantly trying to reach her, and he can't reach her. And so that's what really heightens the anger that he's in. So he walks into the house. I don't want to use the word insane in the legal sense, but obviously very emotionally upset, and not thinking quite straight. And so he then, he gets the tire iron. For what reason? Maybe it's to kill her. Maybe it's just a show of force. But the fact that he drops it and then goes for a knife, I think, clearly shows he has no clue what's going on. I mean, if he wants a tire iron, he has to wait till his wife gets home before he can even get that. So, I mean, I don't see a lot of planning going on here, a lot of cool reflection, and that's what I was saying with the CCP argument. Now, on the guilt phase, I argued that these phone calls that the husband was trying to make, there was two things: phone calls plus the attempted text messages. And then the effort to make phone calls, which apparently the phone company can record. And there was motion to exclude that at trial. The court denied it. But then what we have is what comes in is from a legal compliance analysis from AT&T submitted an affidavit saying these are the phone numbers I downloaded that can be identified with John Philippe's cell phone. Then a police officer also downloaded, apparently, and I mean, this is the world of texting we get into, downloaded the actual text messages that Philippe had stored on his phone. And it was either a detective or a Sergeant Bowers who then testified at court about these messages. And then what we're saying here is that was inadmissible because it was hearsay, not only hearsay, but it was hearsay within hearsay, that this court in Brooks said you can't do. You can't allow, you've got to be able to, unless the person who downloaded those messages was personally aware of the information, you can't let it in as a business record exception. So what we're saying then is the court erred in letting this hearsay come in, and that error was sufficiently damaging that damning to the defendant's case that he should get a new trial. Thank you very much.
Steve White, representing the appellee, Attorney General's office. Consistent with the court's questions, he didn't come to the door with a dozen roses. He came there with a heavy metal object, whether we call it a tire iron or a tie jack. We know it came from her trunk, and the screws matched from the tire instrument, heavy metal instrument, with the screw holes in the trunk. So we have a heavy metal object. He misrepresents himself as a pizza man. The first thing he does is he bashes Roya in the head. The glasses fly off of her, and she stumbles and cowers into the bathroom. And from then on, almost continuously, Roya, the sister, hears Elke, the victim, the murder victim, screaming. At some point, Roya runs out. The sister runs out of the apartment. The neighbor, though, she's next door. She hears what she characterizes, her words, a blood-curdling scream next door. And she goes back and forth between the two apartments. Of course, 911 is called at some point. And she testifies that for over or at least 15 minutes, she hears these screams, all female screams inside the apartment. Let's don't overlook the 52 to 53 cut and stab wounds of the victim also. Let's don't overlook the 6 to 7 blunt instrument wounds.
I think, though, the problem, and I when you start to get into that there's a frenzied stabbing, which supports HAC, if you don't have the part where he's lying in wait and starts to do something immediately as he comes in, the fact that it's a frenzied killing does not really support your argument of CCP. I agree with you on everything else, but we don't, there are two different types of aggravators. And, I've always thought that the person who is calculated and brings the gun ends up with the CCP, but not HAC, but somebody who is not really thinking of how they're going to kill somebody has HAC. But I think, again, so you don't talk yourself out of CCP, the fact is that the actions that he took, waiting, taking the iron or whatever it was,
getting it out of the trunk,
taking it, and immediately when the door opens. But I think the frenzied killing doesn't necessarily support CCP. It supports the weighing heavily of HAC.
And I don't want to, of course, talk the court out of the evidence that supports not only CCP and HAC, but the medical examiner also testified. He expressly said, due to these injuries, these wounds are all over her body from all directions. including a stab wound to the head, deep knife wounds to each lungs, the liver, every angle. The medical examiner especially said, given the nature of the wounds, this was not a frenzied killing. Expressly testified as an expert this was not a frenzied killing, which supports the cold element of CCP. Of course, we also have the calculated part, getting the tire, et cetera, et cetera. And again, let's don't overlook the 6 to 7 blunt force injury wounds. My opposing counsel indicated that he dropped the tire iron right away. Well, maybe he did, maybe he didn't. I mean, the bottom line is he came in there with one purpose. So as soon as he got rid of Roya, the sister, and she cowers in the bathroom, he goes after Elke, the murder victim. And given the blunt force injuries on her, he used something other than knives to injure her. I mean, there's a reasonable inference that actually he used the tire irons or tire jack on her as well. He used something blunt because the medical examiner said there were 6 to 7 blunt force injuries on her as well. But the medical examiner expressly testified this was not a frenzied killing, and there's competent evidence to support that opinion in terms of the knife wounds all over her body, including a knife wound to the top of her head where the knife penetrated the outer layer of the skull.
We have ruled before that domestic dispute, the emotions involved in domestic disputes are not an excuse pretty much for a frenzy type of killing.
Yes,
but you would agree that in these domestic type of issues that there is an element of frenzy involved in them, whether it rises to the level of something like that.
I cannot agree with frenzy. I would agree with emotion providing a motive which provides the background for the calculation and the coldness.
I mean, there has to be some type of highly charged emotions involved when you repeatedly stab somebody 52 times. You can just picture it happening, just stabbing, and there has to be some kind of emotions involved, whether it rises to the level of frenzy or not. I don't know.
I mean, again, the difference between frenzy, it purposes the law, with determination and motive and the emotion that supplied the motive. But otherwise, the court will be going back to what it's rejected. That is, any domestic emotional killing would be an absolute defense, a per se defense to CCP.
But I don't understand. What did the medical examiner use to say this was not a frenzy? Because I don't think that the fact that there were stab wounds in multiple places necessarily negates the fact that it could have been a frenzy.
Well, from all different angles and multiple defensive wounds too, Your Honor. And don't forget the neighbor who heard the screams for 15 minutes. This was a determined killing. And getting the tire iron out. How was that?
Did the medical examiner actually say anything that supported his opinion that this was not?
He said that due to the nature of the wounds from all angles over all parts of her body, that in his opinion it was not a frenzy killing. But
are you saying that I see this? I mean, again, it seems to me you are really focusing on something that is not necessary for the outcome of finding CCP. And I think you're hearing some question about when somebody stabs someone 50 times, there is something else going on in their brain. It's not like he tied her up and then he decided he's going to torture her. It's like as if, I mean, if he was CCP, he would have given her the one, a blow to the neck and made sure that she was dead. But I think this, to me, it shows it's supportive of the kind of what Justice Labarga was saying, the kind of emotion that was going on because she was divorcing him. And again, I think it shows HAC, but I just don't think that's your strongest argument for CCP.
Well, I think the strongest argument for CCP is that he coldly, he wasn't in a frenzy when he unscrewed the car jack.
I agree with you. So I mean, I think you got there. It's okay.
In terms of Hardy, by the way, I think Your Honor put her finger on it. Hardy was a spur of the moment killing, and in that spur of the moment after that, he tried to kill himself.
Yeah,
This
it
was
is
not a
totally,
spur of the
totally
moment.
different. I just looked it up, and I remember it because it was a Palm Beach County case, and
Yes,
it was
ma'am.
a tragedy that occurred there.
In terms of, if there are no further questions on CCP, in terms of issue 1, here are the 2 exhibits. We've had confusion both in the trial court and on appeal in the initial brief in terms of what the exhibits were and what was raised regarding the exhibits. Here is State's Exhibit number 86. These are the AT&T logs of calls, no content, just logs of calls, number called from, time and date. That's it. These are billing records. These State's Exhibit 86 was pursuant to the AT&T certification as a business record, and it's a billing record. I mean, this is clearly not Crawford, but Crawford is what was raised below, by the way. Initial brief does not raise Crawford other than it mentions confrontation in the issue statement, and it says that down below, counsel raised Crawford. He doesn't develop there's no developed Crawford argument in the initial brief at all. The other exhibit, the text messages, is 87. These were not pursuant to the AT&T certification, contrary to what defense counsel initially argued below. These were downloaded from the defendant's phone, the phone that he had in his pants pocket when rescue came. These were downloaded by a forensic officer, an officer trained in forensics, and consequently they show conversations back and forth between friends and acquaintances. Consequently, there's no Crawford issue. It's not testimonial. The text messages show information that he was getting that motivated him to do what he did. There are a number of party admissions in there that he made in terms of making the statements. But the bottom line is that down below, a Crawford issue was raised, not the issues that were raised in the initial brief, developed in the initial brief. A Crawford issue was raised only as to what was certified in the AT&T records. Since the text messages and State's Exhibit 87 were not part of the AT&T certification, these weren't attacked down below. In fact, when the prosecutor mentioned that, no, I'm not going to introduce the text messages pursuant to the AT&T certification, this was after defense counsel made the statement that I think is mentioned in the reply brief that's still confusing the two, but the prosecutor clarified that. And then right after that, the judge asked defense counsel, you have any other arguments? And he says no. In fact, later on, defense counsel wants more of the text messages included to show the jury, to show the context. And, of course, some of these also, are, from the State's perspective, show the context in terms of one message responding to the other.
So there's no Crawford objection on the party admissions coming through on the text messages?
On the text messages, yes, Your Honor. The Crawford objection was as to whatever was certified by AT&T. And, of course, the State's argument on if we go to the merits of the AT&T records, it's clearly a routine business record. It's a billing record. There was a certification by somebody who swore to that from AT&T. It's a routine billing log of phone calls. Also,
yes, sir, historically, it's the business record exception to hearsay. Wasn't it one of the ones cited by Justice Scalia in Crawford as being one of the initial, exceptions to the hearsay rule? And I seem to recall reading something in Crawford about that.
I believe one of the opinions in Crawford does expressly state that routine billing records, business records, are not testimonial for purposes of Crawford.
He said it was one of the initial exceptions to the hearsay rule historically.
Yes, Your Honor. So if you do go to the merits of Crawford, it clearly does. Neither one of these is testimonial.
Well, what were the billing records introduced for?
Actually, Roya, the sister, testified to a lot of what was in all these. But in terms of the AT&T records, they showed 74 phone calls that the defendant made that day to, I'm not sure if it was just the victim, Elke, or whether it was also included her sister, basically.
I mean, it would seem to me, frankly, that this would show sort of this same idea that it was really he was trying to reconcile with her. I'm not sure that those records are particularly harmful to the defendant.
I would totally agree, Your Honor. And again, in fact, Roya testified, the sister testified that our phones were going off all the time as my sister was bringing me back from the airport, and we got back to the apartment. And at that point, I told him, "Don't call anymore." That's what one of the big text messages is. So we've got her testifying.
But I'm saying the records were really to show the number of calls. The text message, how did those come in? What was the actual content of any text message?
Basically, along the same line, Your Honor, that he was preoccupied.
No, I'm saying how did that exhibit? Was that created, or does AT&T doesn't keep your text messages?
These were not from AT&T, no, Your Honor.
Oh, okay.
Please, again, this is now we're talking about.
It comes off of her phone. Is that how they get them?
No, Your Honor. 87 again is not from AT&T. These are the text messages.
And how did what I'm asking you is where did those? How was that created?
These were downloaded from the defendant's phone, cell phone, which was in his pocket when he was in the cab too. By the way, the taxi cab driver says the defendant used a cell phone on the way over there. Okay. So, but rescue also got this phone out of his. Or the police got this phone out of his pants.
Well, did
pocket.
they? Then they could. So, what was the objection to those?
And it's his phone number. That's an excellent question. You're down below because
it's an admission. It's his phone and it has his text. He's not saying someone else. I don't think the defense was somebody else had taken his phone and was the one that texted it.
There's not one indicia, nothing, not one scintilla of anything to indicate these did not accurately reflect.
And what did the
was on his
text
phone.
messages say? They're saying, "Please, I want to talk to you."
Same type of thing that we had through other evidence, Your Honor. He was preoccupied with her leaving him. He didn't.
It seems to me, again, it's helpful. I may be wrong about this, but it seems that it supports a defense that he was trying to reconcile with her. So,
it's just part of the total picture. It overlaps very substantially with the other evidence in the case because Roy already testified to a lot of this stuff in terms of the phone calls, conversations that she had with him. So, and clearly, if somehow it was preserved and if somehow the court found that there was error, it was clearly harmless for the reasons, among others, that Your Honor's indicated. It overlapped a lot with the other evidence.
Well, since text messages may become more and more of an evidentiary issue, and they may be an evidentiary issue in appellate cases, from the point of view of the state, is there a better way to introduce text messages than what was done in this case?
In this particular case, since the defense didn't pursue it, the actual officer who was trained to download the messages didn't testify. The detective testified as to this.
But that's what you would do. You'd go through.
If it were contested, I'm half speculating here, but I have no doubt a competent prosecutor would have put the officer on who actually downloaded them, who would have testified as to how he downloads them, why he does it this way, how they're stored in the phone, et cetera, based on his training. In this particular case, that forensic officer did not testify. The detective testified, gave a gloss, basically, if you would, of what that testimony would have been. But again, this goes back to preservation. There was no reason to lay that detail to predicate because the defense wasn't contesting it at that point. There was at one time, the defense counsel said, well, subject to the objections that I've already made. Well, we go back to the motion, which didn't preserve this at all. But for all these reasons, the state would request that the court affirm the conviction and sentence. Thank you, Your Honor.
Thank you. Rebuttal.
The Crawford issue was, I didn't develop it particularly strong in the initial brief, but I certainly did in the reply brief. I went back and said that the information that was downloaded was testimonial. If you look at...
how could that possibly be testimonial? I do not understand that argument, that's testimonial.
Sergeant Bowers, when he got on the stand, brought in these records, and they were developed specifically for this trial.
But the records were on the phone.
But that's true. That's true. But then
that wasn't developed for the trial.
That's exactly right, and that's exactly right. But the officer who downloaded those specifically for trial. The AT&T compliance officer downloaded it specifically for trial. That makes it testimonial.
But the substance of it was not testimonial.
But
I mean, do you have any case that supports that proposition?
Yeah, Davis versus Washington. I mean, that talks about let me see, was it this court?
It's one thing if you create the substance of something with a view toward trial, like a test or something like that. But this is simply going through a mechanical process of downloading what is already there and is not testimonial.
Well, I think it is. I mean, we've got a lot of disagreements here, but I think you look at Belvin, and that's kind of, it was, I think, a breathalyzer test there. It was the same thing. They developed that breathalyzer test specifically for trial, and it became testimonial. If you look at the analysis,
but they did the test for that purpose. These phone calls or text messages were not made for trial.
That's true. But when they downloaded it, and they specifically went in to download all those text messages, all those calls, specifically for trial, that made it testimonial.
So how would you, Mr. Davis, because this is obviously comes up and will come up time and again, text messages, the defendant's text message. You're not saying it wasn't. Are you saying it wasn't his phone? It didn't come from his phone?
Well, let me say this: it was from his phone. But this is another point. There was no evidence that he made those phone messages.
Now, was that the objection? Now, that's so was that the objection below, that it is not relevant because, although it was his phone, somebody actually was, other than him, was harassing his wife that day?
I don't think it was somebody else. I think that they're just holding the states to the proof. You've got to show that this phone calls came, that John Philippe made these phone calls. All they downloaded was it came from his phone.
But wasn't that corroboration by the sister anyway, that she verified that he was calling her repeatedly? So those are the calls. But I'm asking, on the text messages, how would a proper predicate be laid to put text messages? You know, we've had voicemails. Right. We have a way that those are done, and there's predicates about voicemails off of a phone. How was the text message?
I think it's the same predicate. You've got to show that the person who made that text message, you've got his little thumbs on the thing, is the same person.
Now, how would you do that other than it's his phone and no one else had possession of his phone that day?
Well, we don't know that. I mean, that's part of what the predicate's going to have to be.
And that was the objection by the defendant?
No,
that is,
it was.
Because I thought you said it was Crawford, which is, I can't cross-examine these records. But now you're saying, no, the predicate was not established, that it was actually he that made these text messages.
It's both of them. I mean, first of all, they never established that John Philippe, even though it was his phone, and there was certainly the strong implication there that it was him, but there was no indication that John Philippe is the one who actually made it.
And you certainly could argue, did the defense could have argued that it wasn't John Philippe making those calls, but I wouldn't think they want to, because like I said to Mr. White, it seems that it fits in with the defense of a guy that was desperate to want to reconcile with his wife.
The state then uses it to show his intent to kill. That's how. I mean, why is the state introducing it? I mean, they're not.
But what was in there that showed that?
What was in there was the 74 calls within a period of an hour that shows just this mad, and that's how the state uses it.
But that's the other exhibit, right? That's not the text message.
Well, the text messages show his efforts to try and talk to us. We can work this out. Please talk to me. Elke's coming back. I'll talk to you later. My battery's low. I mean, it's showing him working himself up. Now, it goes to the CCP to negate that, but during the guilt phase, it certainly is going to be states using it.
What was the specific objection at trial?
They objected to. First of all, they objected to the AT&T. They objected to those records coming in, and there was also
on the basis
of what
grounds? What's the specific objection?
Well, they raised. I thought the way I read it, and when you read their written motion, they were objecting to all of it coming in, the text and the phone numbers.
On what grounds?
Yeah. Well, they cited Brooks, that it was hearsay within hearsay. They were citing Crawford, that it was testimonial evidence, and so those are the grounds, and those are the grounds they argue.
Both of those.
Right, Brooks. I mean, it's in the written motion. They cite Brooks and Crawford. So I mean, their argument's testimonial. Now, Justice Kennedy, I think what you need to do is, if we look you got to look at the Brooks issue, that it's hearsay within hearsay sort of thing, and that's where it becomes testimonial. By the time it gets to Sergeant Bowers, the one who actually testified, then it becomes testimonial evidence.
I don't understand how it's hearsay at all.
Well,
the text messages, because it's not shown, they're not introduced to show the truth of the substance of the statements. They're just introduced to show that he made those text messages.
Well, by the time
isn't there a difference there?
No. Well, by the time they get to Sergeant Bowers is talking, and this is the guy who testified at trial. He's saying, here's the truth, that the defendant is trying to reach his wife, as shown by his efforts. And that becomes a hearsay within the hearsay. Okay? Thank you very much.
Thank you for your arguments. The next case for the day is Van versus Smith. You may proceed.
May it please the court. My name is George T. Reeves. I'm here representing the petitioner. With counsel table is Edwin B. Browning, Jr. In this case, we feel that the district court below erred by failing to apply the correct standard when it reviewed an order granting new trial. This court has clearly enunciated its standards that it wants appellate courts to apply in these cases, in the case of a state of Stoukie, and in the E.R. Squibb case that was decided about 2 years before.
But we just after the trial, there was zero verdict. Liability was admitted?
Liability was admitted, but there was a finding of no causation.
So there was a specific, so no medicals, nothing?
Nothing.
And the judge said in his order that if there had been even a small verdict, it would have been different. Now, my question is, there was also, you moved for a new trial, and you also, did you move for what other motion was made post-trial?
Well, we filed motions for a new trial, and that motion for a new trial cited several different reasons, such as one of them was there was an assertion there was a problem with a juror, that the juror hadn't revealed everything they were supposed to in the voir dire.
But those were not addressed, and no, you didn't pursue any of those.
The trial judge granted the motion for new trial on manifest weight of the evidence, and in his order he said, this renders the rest of the moot. I'm giving you a new trial.
Did you move for a directed verdict on the issue of causation? In other words, so that there was, if it was uncontroverted, which is what you're asserting, that there was causation, was it appropriate for a directed verdict?
We think it probably was.
But you didn't. You have not. And you renewed that in your motion for new trial.
We
but did not pursue that after the judge granted it based on manifest weight of the evidence.
Correct. And I think there's a difference there, Judge, and it illustrates the difference in reviews on the motions for new on the directed verdict and motions for new trial. In this case, all of the expert testimony, including the medical doctor from the other side, all agreed there was at least some causation. There was non-expert testimony or non-expert evidence, such as the lack of damage to the car and those types of things, that was going on the other side of the expert testimony. I don't know that it necessarily would have been appropriate for a directed verdict, because there was at least some evidence on the other side. That doesn't change what the appellate court was supposed to do, though. The trial court looks at it and decides whether or not the manifest weight of the evidence was on the other side of the verdict.
Now, here is the first district and then the fifth district has said that if there are errors of law made in the judge's order, you've got to look at what those errors were, and you don't give like total deference to the trial judge if there are errors of law. So how do you address the fact that if this trial judge had taken out those? First of all, do you agree there are some incorrect statements of law in the trial judge's order?
The way I would phrase it is, I think the trial judge's order passes muster. It is certainly inartfully drafted and should not have been.
Well, the idea, you can't say, I mean, a jury is free with that to reject expert testimony, but there's with some qualification.
Correct.
Okay. Does there have to be expert testimony on causation?
No.
So those are two. So those are two errors. Now, how do you decide? They said if it's premised on an error of law, how do we get inside the judge's mind to go, well, if the judge had taken those two statements and stated them correctly, this would pass muster under all the other cases? In other words, the judge was really saying, listen, I was there. I listened to all the evidence. I heard all the experts. You had an IME, whatever they call them these days, who basically, I don't know how you get that up here, right, who said it's related, and then defers to the treating doctor. So you kind of are there as the trial judge afterwards saying there had to be some verdict, and yet the judge has made those statements. So how do we then, what's wrong with saying that there has to be a different standard when there are errors of law made? The question is what the standard is.
There's two parts to that. Number one is the ideas are not mutually exclusive. It is proper for the jury to evaluate the evidence and the testimony, and it is proper for the jury for that to be the province of the jury. That doesn't take away from the fact that the trial judge is to make an independent review of the evidence, and the trial judge is to determine whether the manifest weight of that evidence is against it.
Well, I agree with you, but now what we have here is not the first district, and you would agree that if there was no evidence to support what the judge said,
right.
Well, you're not going to give them the order deference.
Yes,
okay,
ma'am.
so that's the first type of exception. The question is when it's premised upon an error of law, you can't give it the same deference. So what do you do with the misstatements or incomplete statements or whatever? Can't get inside the judge's mind. For example, wouldn't it be the proper thing to do, say, it looks like the judge was getting it right but made some misstatements, to say this is the correct way to evaluate it, send it back to the judge to let the judge reevaluate it without those incorrect statements?
Absolutely, and we've asserted that in our brief, that if this court were to agree with the first DCA and say, well, we think there were some errors of law here, that the trial judge made some errors of law.
Well, I'm asking you, though, there were errors of law.
How
do you evaluate, how does an appellate court, when a judge has made errors of law that are there, like this one, and talk about reasonable jurors, which is really a different, talking about directed verdict standards, how do you go and say, well, in that one, I'm still going to say whether a reasonable trial judge would have made that decision? A reasonable trial judge that erroneously states the law, it doesn't fit anymore.
What the trial judge is required to do is to make a finding, a manifest way to the evidence, and the trial judge is required to set out his reasons. In this case, the trial judge made the finding, a manifest way to the evidence, and the trial judge set out his reasons. So we think that order beats muster. He included some bad statements in there.
So you would say, really, this wasn't premised upon errors of law.
Absolutely.
And that would be the distinction you'd make.
Absolutely, because the trial judge doesn't go, the whole order isn't the jury erred. The trial judge says manifest way to the evidence is against the verdict. This is why. It lists out the experts and says that they were all against the verdict and all of that. Now, he says in about 2 or 3 places no reasonable juror would have found. That, I think, it is very proper to deem that as surplusage, because the trial judge has done what the trial judge is supposed to do, determine the manifest way to the evidence.
But isn't that the standard for a zero verdict or an inadequate verdict?
I don't know that I'm following, Your Honor.
Isn't that the standard be applied in evaluating a zero verdict or an inadequate verdict? No reasonable jury could return this verdict.
Yes,
you
Your
go
Honor.
back to, well, I mean, that's what we're dealing with here, aren't we?
No, because under
you don't think we're dealing with that?
I think under the estate of Stoukie and Squibb, what the trial judge does is determine the manifest way to the evidence. That doesn't mean there's no evidence on the other side. That doesn't mean no reason.
You're not contesting then that you're here because this is either a zero verdict or an inadequate verdict for the plaintiff in this case based upon the evidence.
We're here because the manifest way to the evidence was against the verdict. And we think that there's adequate evidence in the record to support that conclusion by the trial court, and the district court should not have overturned that, should have given the deference that this court has required it to give under Stoukie and under Squibb.
Well, what was the judgment of the trial court?
The trial court, the jury said had a zero verdict. The trial court
entered an order. That's what Justice Lewis is asking. I mean, that's his whole point of inquiry. We got a zero verdict here, right?
Yes, sir.
So that's what we're dealing with.
Yes, sir. Absolutely.
But there's I think, and this is where, like, I recall years ago where there was consortium and there would be zero verdict for the spouse, and then you'd say there should be a new trial because it was inadequate verdict. And I think I asked you had pursued that line with the judge, which would be a different, but you're conceding here that although it was a zero verdict, a jury could have found no causation, but that on the other hand, it's against the manifest weight of the evidence. So there's two different. Do you understand the two different things that you could have done?
Let me try to clear that
up.
I think that an appellate court, in reviewing the jury verdict, could possibly have found there is competent substantial evidence to support the zero verdict. The appellate court could have said, look, and if what we're looking for is competent substantial evidence, there's a little bit of that over here and manifest weight of the evidence over here, it would be supported. That's
I think
different
you just stipulated yourself right out of this court.
I sure didn't intend to, Your Honor.
Well, I think you just did.
And this is why. I don't think in Stoukie and in Squibb it doesn't say 100% of the evidence has to be against you, against the verdict to get a new trial. It merely says the manifest weight of the evidence. When you say manifest weight of the evidence, I think that means there's at least something on the other side that would qualify as competent substantial evidence.
Let me go back to this issue about the legal error. Now, I think there's an argument here that there was a factual error also. But let's focus on the legal error. It seems like to me that when the trial court makes a legal error in the process of analyzing this question of the manifest weight of the evidence, for us to say, oh, well, no harm, is somewhat problematic. Because the trial judge obviously thought that conclusion of law was important to the conclusion, and I don't know how we can just come along and extend deference to the trial court's ultimate conclusion when it is tainted by such an error of law. Now, what am I missing there?
If Your Honor wishes to, if the judgment is that there was an error of law, remand it to the trial court, let the trial court fix it, that's fine.
That's a separate issue. I understand that, and I understand that point,
sure.
And I think that's a respectable point.
The problem is what the trial judge did everything he was supposed to do. The order supported by evidence in the order. The few times he does reference jury verdicts, he says no reasonable jury would have found X. The standard here is whether or not.
But he's saying no reasonable. But he's also saying no reasonable jury could have discounted the expert testimony, and we know that there is law which is contrary to his general conclusion about that.
There is, and that's not in conflict with Stoukie and Squibb, which say the trial judge can grant a new trial on manifest weight of the evidence. So the jury is allowed to resolve evidentiary conflicts, and just like it did in Squibb, where you had two experts that conflicted, but the trial judge does get to come in.
The judge here is looking, and he's analyzing this in terms of what the jury saw and whether the jury's verdict was against the manifest weight of the evidence.
Yes.
And I understand your point, but it seems to me to be highly problematic for us to affirm, for there to be an affirmance of a trial court judgment where there are these errors like this that affect the analysis.
And the way to
you saying it's just kind of irrelevant to the analysis.
And I think the way you would phrase it is, if the trial judge is saying that no reasonable jury can find this way, how do you argue that the manifest weight of the evidence is not against it? The manifest weight of the evidence would certainly be subsumed.
But he was saying that no reasonable jury could do something that the law says they can do. I mean, that's the part of the problem here. That's part of the warp and woof of this whole analysis.
But no one was reviewing the jury verdict. No one properly was reviewing the jury verdict. They're properly reviewing the order granting the new trial, and all we have to show is manifest weight of the evidence. So
I think your problem is really this, that when you're talking about the manifest weight of the evidence, what the judge is saying about no jury could have not found the causation really is a part of his analysis of what the evidence was. That's a part of his manifest weight of the evidence. That's what he's finding. And so, but that's incorrect. You can't add that to that analysis because a jury could disregard expert evidence. I think that's where the real problem here is. He's taken that incorrect statement and placed it in the part where he's looking at the evidence.
And I think
weight of the evidence.
I think I agree with what Your Honor, Justice Quince, I think I agree with what you said. I don't think that's harmful error, though, because if the trial judge says no reasonable jury can find this way, certainly he thinks the manifest weight of the evidence.
But if you took that statement out what evidence what now is the manifest weight of the evidence? We can't now take that out and say, oh, even without the statement, here is the evidence that shows this is the manifest weight of the evidence. I think that is where the real problem is.
The page and a half, though, in the order where he goes through and says there were 3 experts, they all found in favor of causation, including the other side's expert. He recites all of that in his order. So there's good support for the manifest weight of the evidence ruling without those statements. The statements that we're talking about are where he's taking that evidence, the fact that there was all of these experts, and then he concludes by saying no juror could find. It's just that conclusion that I think is harmless.
Well, you see, I think that we're looking not at this just at this case. We're looking at all other cases. I do think that from my point of view, the First District did, when they then went on and said there's competent, substantial evidence to support what the jury did, they are then disregarding the way that we said this whole manifest weight of the evidence new trial situation should be looked at. But I don't think it really is a good idea to place in the appellate courts trying to slice and dice whether the error is, it's pretty, it permeates it enough that to try to say the judge would have reached the same conclusion without it, I think would be not, especially when we want the reasons stated.
Sure.
I just think you don't want to be trying to argue that in the appellate courts.
And I certainly respect that viewpoint.
I mean, obviously, if the judge cited a case that was overruled, you'd go, well, he cited the case to say, well, he would have reached the same conclusion. How do you know that?
You're right. And I certainly respect that. And I think if Your Honors are intending to remand it to the trial court and say, fix this problem, that would be a just result. But I think if you look at the actual order itself, the references to what the jury should have done are very few and far between, and there's copious amounts of explanation on why the judge thought the manifest weight of the evidence was against the verdict.
Was this an order that was prepared by the trial judge?
Yes, Your Honor, unfortunately.
Okay. No, I just want to make sure this was not. I mean, so the judge announced that this is what he was doing, or this is.
No, the trial counsel went. Trial counsel and I prepared the written motions. He went and argued them, and then the judge did not announce his ruling. And next thing we know, we get a.
Well, it's a very thoughtful, comprehensive order. It's a senior trial circuit judge that heard this case. But it sounds to me that I think that what is also very credible about what the judge did, it said had the jury found causation but allocated only a minor portion of the causation to the collision, a new trial would be unlikely, which sort of goes back to that if there had been a $10,000 verdict or a small verdict,
right,
the judge wasn't going to be granting a new trial.
Yeah, and I think that's absolutely the position of the judge, and I think that goes back to what we've got here in the way of evidence. All of the experts testified there was causation, but they don't all agree on the amount of the damages. So,
well, there was also the issue that the back injury, where he complained before, was not related.
That's correct.
And that is where I think there's some confusion of, in terms of the facts, but it also says he didn't report cervical pain for 16 years, but we know there is entry in records 6 years before where he has cervical pain. But the doctors had all this information when they made their decisions.
They did. And remember, what the other side is doing is they're saying, you've got all these experts, here is some non-expert evidence that supports the jury's verdict. This court in E.R. Squibb supported a trial judge's grant of new trial when there was conflicting expert testimony. And the two experts didn't agree, and the DCA reversed citing very similar case law and in very similar method to what was done by the First District here. This court reversed and said, look, when we look at this, we cannot say that reasonable people could not differ as to the propriety of this order. We weren't there.
You have about a minute and 30 remaining. You want to say that for rebuttal? Okay.
Your Honors, Richard Sherman and James Sherman, co-counsel for the respondent. I will argue, just do the introductory remarks, 2 or 3 minutes, and then turn it over to my son James. He argued this in the First District and won it, so I'm going to have him do the substance of it. But
You didn't make a decision to let him argue it?
Well, I need to do the for client relations.
I'm just
the overview. You know, he can do a better job than me. I guarantee. He's done 28 oral arguments.
Maybe you ought to let him do it and not mess it up.
Yeah, right. Basically, when the question is when the judge has clear errors of law in the order granting new trial, but cites some magic words against the manifest weight of the evidence, do you just disregard that? Or
no, but Mr. Sherman, again, and I think that the issue really is, but if there's an error of law, but there are paragraph after paragraph after paragraph of careful analysis of the evidence, then do you just disregard all the paragraphs of careful analysis of the evidence that led the judge to say, I can't believe the jury found no causation? It's against the manifest way of the evidence because he made an error of law. Isn't the correct thing to do here is not to say there would be evidence the other way, but to remand it to the trial judge? The
judge said the jury, you need an accident reconstruction expert, and so it's against the manifest weight. If he'd known that,
you can say that, but I've got the order in front of me, and I don't think that that's a correct characterization of what this judge did throughout almost 5 pages of his order.
And then
Let's not talk over each other, okay?
Pardon me?
I'm talking.
I'm sorry.
Okay. Over 5 pages of this order is careful analysis of the evidence in this case. It's not sprinkled with errors of law. And maybe you haven't read the same order that I read.
Yeah, it has the 2 clear errors of law. It also says a jury can't reject uncontroverted medical evidence. And once again, if he had known the jury can, then it might not have been a manifest weight if he had known that was proper evidence.
I have a basic question on how this case should go. Should I ask you or wait until your son comes up?
Oh, why don't you wait to that? I'm just going to be another minute.
All right.
The Supreme Court cases and the rule has always specified the judge has to state the reasons when he grants a new trial. So, I mean, there's a reason for that, to make it amenable to appellate review. In all types of standard of review, the more a ruling comes to errors, to questions of law, the less deference to the trial judge. And so we think clearly this is a situation where when there are 2 errors of law, you can't just say, well, you don't know what degree that infects the whole reasoning. I mean, if he'd known that they could reject it, then it might not have been against the manifest.
But isn't the issue really here the remedy? And I guess is your son going to talk about the remedy? I agree with you on this issue that if you have errors of law, you can't give it the same deference. It's logical. It would be illogical to say it. But once you've done that, then what's the remedy? What the First District did is they went through as if they were the trial judge, reaching the other conclusion, as opposed to saying, let's remand it, let the trial judge make sure he's given the correct law, and now evaluate it to see if you still think it's against the manifest weight of the evidence.
I think practically all of the appellate cases, once they find the reasons are not adequate, then they just reinstate the jury verdict. And
but would you agree, without the misstatements of law, this would be an airtight order granting a new trial?
Well, yeah, without the errors of law, then it would be reasonable person. But there are 2 errors of law. It's a very
No,
big
what I'm
errors
asking
of
you
law.
is that you have, including your experts, saying there was causation. You had a rear-end collision by a drunk driver. The guy goes to the hospital. He gets medical treatment, and the jury says no causation for any of his damages. And the judge carefully reviews all the expert witnesses and says they all were consistent that for the cervical injury, this was related. That would not be, under the cases allowing new trial for manifest weight of the evidence, a properly upheld on appeal?
Well, it said that he totally rejected the fact the jury could find no causation because there's a little scratch, and that our expert said it could be caused, but he said they couldn't reject that. So I'll turn it over. Thank you, Your Honors.
Good morning, Your Honors. James Sherman on behalf of the respondent. It's a good thing you didn't put any pressure on me. Sorry.
That's all right. Welcome to the court.
Thank you, Your Honor.
Going to the substance of this, why should this case not be analyzed under the same standards as a zero verdict or an inadequate verdict or an excessive verdict?
Well, because, Your Honor, it contained expressive errors of law. And to put it...
No, the standard. I understand that, but we have a long list of cases that have been litigated over the years, and it's always the same standard. And here you would have to find that whoever the plaintiff was not even entitled to go get checked out. Come back with a zero verdict, wouldn't you?
Well, I guess in terms of the standard, Your Honor, then how would you apply the no reasonable person standard to an error of law? That's where the problem comes in.
You're trying to mix these two together. I'm asking a very simple question. If this is a zero verdict case, and we know a collision occurred, there's admission of liability, there's not a liability problem, we know that the cars made contact with one another, to uphold this verdict, you would have to say that even whoever the plaintiff was here, I don't even know who the name is, it doesn't make any difference, that person was not entitled to get checked out, to be able to support, to go get an exam to see if they're hurt.
If you're saying if it was just the order without the errors of law.
I'm talking about the case. I'm not worrying about the order. I'm worrying about the case.
As the verdict stands, the jury would have to find that the plaintiff did not suffer any permanent injury as a result of the accident.
Well, I don't know about this permanent injury stuff. The question is, you come back with an amount. Is this a no-fault kind of verdict form that we're dealing with? Did the plaintiff sustain a permanent injury within a reasonable degree of medical probability?
I'm not sure what the exact verdict form was, Your Honor.
Well, it becomes important, doesn't it? Because if we're looking at a zero verdict, we look at it in a different way. Well, and that is, the question is that, okay, you're in an accident, and you may not have a permanent injury, but you may still be entitled to go get checked out.
Well, I don't believe that we briefed the issue of the zero verdict, but I do believe there are cases that say that even where there was no award for being checked out, that they can still uphold that.
Oh, I disagree with that. People that are involved in an accident, you may fight all you want over how badly someone's injured, but that's why the courts have protected against zero verdicts, that you at least are entitled to go check it out. That's why they say that if some verdict had been rendered $50, that it may have been adequate and sustainable and not reversible. But the zero verdict puts it in a different category. I'm sorry, I disagree with those. Have you checked out the Florida Bar publications on inadequate and excessive damages?
Yes, Your Honor. I believe I recall seeing cases in Westlaw about zero verdicts, and they didn't award anything for being checked out, and they found that it was upheld on appeal.
Okay. How does PIP enter into this? Does that have anything to do with this case?
Not that I'm aware of, Your Honor.
Okay.
Well, the question, I guess, I think that if we are looking at Brown versus the estate of Stoukie, it says with respect to ordering a new trial, a trial judge may order a new trial on the grounds that the verdict is inadequate or excessive, or against the manifest weight of the evidence, or both. Now,
Correct,
as I'm
Your Honor.
understanding it, this was argued before the trial judge on both bases, but the trial judge granted it based on manifest weight of the evidence.
That's correct, Your Honor.
And the plaintiff did not pursue that it was an inadequate verdict on appeal to the First District.
That's correct, Your Honor.
Okay, so we have to go back to look at the Brown v. Stoukie under whether on the manifest weight of the evidence. Now, I just want to make sure, because once the judge has made these errors of law, and I don't like I think if it was the wrong site or something, it would be one thing, but where it is there in different parts of the order, is what it seems that what the First District did, maybe with your excellent advocacy, is basically engaged in their own evaluation of the evidence to show that there was evidence in the record to have supported the jury verdict. Now, so I ask you, wouldn't the remedy be, and it would give you a chance to re-argue this, that the judge needs to be remanded to the trial judge with the correct law, as you stated, and to evaluate whether, based on his superior vantage point and all the things that he watched during this trial, whether it is against the manifest weight of the evidence. It doesn't seem what the first district did was the correct way to approach this. It's like they took what we had rejected in Squibb and the other cases to say that, no, you don't look at whether there's evidence the other way. You have to see if the judge's verdict or whether a reasonable judge could have reached that conclusion, right? That's what we would do.
Well, Your Honor, I think the difficulty in that is that if you remand it, we already know what the outcome is going to be, is that the trial judge will correct his order legally, but in this case, he had these legal errors where he totally discounted a whole bunch of evidence, so there's no reason to think that when he reviews it again that it'll change the...
Well, but on the other hand, if he had left out those incorrect statements, you'd be, toast on appeal. You wouldn't, right there. I mean, you have to.
Yeah,
okay. So we have a senior judge who I don't know how old the senior judge is, but he's still entitled to the same deference as a full-time judge who, instead of saying that expert testimony can be, if the jury is entitled to disregard it, if there's a reasonable basis to disregard it. And I think where you have the biggest problem is that your own expert said, I know all these other things. I don't think the back is related, but I think the neck is related. I don't think he's as injured as they think, but I cannot discount that the cervical, the surgery, the guy undergoes surgery, is related to the accident. Your own expert says that up here. They might not say that in South Florida, but they said it up here. How do you take that and say that the jury still said, too bad, I'm not going to award anything?
Well, Your Honor, I think first our expert's testimony wasn't quite that strong. My understanding is that he said it could be caused by the accident. It wasn't. That was my understanding of it.
You want to go through his? I mean, it was pretty strong. I mean, I did read it a couple of times because it was. It was. It seems to me weren't you going for like a small verdict as opposed to no verdict, and somebody.
Well, I think we're happy with either one, Your Honor.
And that's all.
Sometimes you got to watch out what you wish for.
And that's all that. I mean, again, new trial. It may be a small verdict, but it's entitled to something, isn't it?
Well, I mean, Your Honor, the thing is, this case is rife with credibility issues. The plaintiff was found to be completely incredible, lying about. He didn't tell his doctors about his previous surgical.
I mean, that sounds good on the surface, but really what happened, this is a guy that wasn't a great historian. That's what his own doctor said. You go into these doctors' offices, you have a 20-page thing. He wasn't trying to hide anything. He told the doctor on questioning, he explained what his history was. And you don't have surveillance of him, doing things that he says he couldn't do. You don't have other witnesses that really say that this guy, just danced around the car after the accident. You had the police officer that said, didn't say it was a scratch. He said it was a good smack from behind. So it doesn't seem like it fits into those cases where, you go, well, I do understand why the jury gave nothing.
Well, Your Honor, our interpretation of the evidence was that it was rife with credibility issues. That he didn't tell his own experts about his previous spinal fusion. Who knows what else he didn't tell them about?
Don't those show up on X-ray?
Well, they did, Your Honor, after the fact. He showed up at trial wearing a neck brace, even though his own doctor testified.
But that would be so. If he got $10,000, like what was the medical in this case?
I don't recall off the top of my head, Your Honor.
Give a ballpark.
I just strictly don't remember.
Was it 5,000, 10? I mean, was it a lot of medical?
I assume it was probably a good amount of medical.
It had to be a substantial amount of medical. So if they gave the amount of the medical bills, you'd say, well, that's all they, or gave them, $10 for pain and suffering.
I take it was there a CME done? I'm sure it was.
Yeah, yes. Troy Trimble was our.
Didn't take X-rays to find the fusion. He might want to find someone else.
Yes, Your Honor. the expert, or once by the time trial came, all the experts knew about the spinal fusion, and they testified.
How did they find the spinal fusion? How was that revealed? How did that come up?
Through X-rays and MRIs. They showed up on there, and at that point,
So it was discovered during the CME.
I believe so, Your Honor.
Well, no, it couldn't have been discovered during the CME. The CME took place after the cervical fusion.
Right.
It was discovered before. I mean, there wasn't any hiding of this.
No. What I'm saying is that the CME, obviously, the CME took place after the surgical.
I'm sorry,
fusion.
I must
The CME X-ray must have discovered it.
I know you're talking about there was a cervical fusion in about 18 years before.
90,
That's
91.
what you're saying.
Right.
He hadn't initially said,
Right.
but
That's
he
correct.
had X-rays. Did he go to the hospital? Did he have X-rays there?
Yes, Your Honor.
Well, so it must have shown up on the X-ray.
Well, I assume so, Your Honor.
I mean, this wasn't the verdict form in this case. And I think it's important. The first question asked was there negligence that was a legal cause of damage. The answer was no. They went no farther. They went no farther as to any damages in the past or the future.
Correct, Your Honor. But Your Honor, I just wanted to point in the trial court's order, it states that is Dr. Trimble's answer to the question was that. I'm sorry, I appear to have lost my place in the order. But the main point, Your Honor, is that this court's order, the error of law is most concisely summarized on page 5 of the trial court's order, in which it says, in summary, the issue of causation under the facts of this case required expert testimony in order for non-expert jurors to make a valid finding. That flies in the face of Florida law, and Florida law is replete with cases that says that the more illegal in nature a ruling is, the less deference it is afforded.
So we agree with you.
Yes,
Say
Your
we
Honor.
agree with you.
Yes, Your Honor.
Why is the remedy not to remand it?
Because, Your Honor, the trial court
I
already...
thought you said, that's right, you said, because this trial judge is going to still give a new trial
under
the correct evaluation, because he was shocked like maybe we'd all be shocked with a zero verdict.
May not be the same judge. If he was a senior judge who presided over this, it may be someone else now.
Yeah, actually, that's an interesting question. I don't know that it could go to another judge. What would happen then? Do we have to worry about that?
Yeah, I think...
Because it's really, we're giving deference to the trial judge who presides over it.
That's correct, Your Honor.
I hope we don't. We'll leave that to the first district or somebody.
Well, Your Honors obviously understand the case, and so we would ask that you affirm the district court's ruling. Thank you, Your Honors.
Thank you.
On this remedy, first of all, how much were the medicals?
Yeah.
You don't know either?
I don't know exactly, but I think it was 20 or 30,000. That's my guess.
Boy, I'll tell you what, if this was South Florida, it would be like 100,000 or something for a cervical fusion. That includes the 20,000, includes the cervical fusion?
I don't know those details, Your Honor.
Okay. A lot of medical. There was a lot of
There's a good
medical.
bit of medicals, yes, Your Honor.
What happens, I don't know, the senior judge, if there is, that same judge is not available, then what happens?
We haven't briefed that issue. The intermediate appellate court cases I've seen on that say that that the motion has to be evaluated properly at some point. And so if this court were to decide, trial judge, you never evaluated it properly, and you don't have another judge that can evaluate it properly, your presumption would be that you get a new trial out of it. I mean, that's what I have, and I'll be happy to provide that as supplemental authority.
You mean that there would be no judge that would evaluate it, just automatically reverse for a new trial? You sure that's the law?
I have found an appellate court case that says that, and I will provide that as supplemental authority, Your Honor. I apologize for not bringing that with me, but that wasn't one of the areas we briefed and all. And
I believe they can read the transcript. I don't know whether you have to read it or not, or you have to.
And
but the problem there is the vantage point that you then defer to is lessened because it's not, we could read the transcript and say, yeah, we could see why the trial judge did that, but we wouldn't, we need the reason you give the deference is because the judge has that superior vantage point that can't be just obtained by the transcript.
I agree.
They would have to agree to that.
Yeah.
Because you obviously couldn't get the...
I mean, you look at it.
I do think as a point of order, though, that Judge Sieg is still acting as a senior judge. I don't think that'll be an issue in this case, but I will provide that supplemental authority. And I do, Justice Lewis, I'm sorry I was a little slow before. I do think I understand your question, and what Justice Pariente is exactly right. That was a question below at the trial court. When the trial judge issued his order granting new trial based upon manifest weight of the evidence, we didn't pursue anything else. And so what's before the court today is the manifest weight of the evidence only.
Going back to the other issue, you might want to go to the criminal cases where there's a motion for new trial and the judge who presided over the case is not around anymore.
Yes, sir.
And there is case law that allows the new judge to read the transcript, especially when issues are raised involving the credibility of witnesses who testified during the trial, and the judge was not present.
Okay. And that's in the criminal context?
In the criminal context, but obviously the stakes are a little higher.
Right.
Yeah, so we have some case law in that regard.
Thank you.
And I think you'll find some civil case law as well.
Yeah. Thank you, Your Honor.
Thank you for your argument. Court is adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.